Hello everyone, myself Vibhu Mishra pursuing first year BLLB from Fairfield Institute of Management and Technology that comes under GGS IPU. So guys, today I am here to talk about decriminalization of 377. As we know, September 6, 2018 was a historic day regarding homosexuality in India. It was a day when people restored their faith in Indian legal system. Section 377 was declared unconstitutional. However, some provisions still remain constitutional. A part of this section criminalized consensual sexual acts between same-sex adults, calling it against the order of nature. The Section 377 of Supreme Court judgment came from a unanimous five-judge bench of the Honourable Supreme Court, headed by Chief Justice of India, Mr. Depak Misra. It was a day when humanity prevailed over sexuality and love battled over all the odds. The Section 377 was considered as the most draconian section of the Indian Penal Code. It says, whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with one or with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. And the court has also explained the penetration is sufficient to constitute the carnal intercourse necessary to the office described in this section. Now we will look at the historical background of the Section 377. The petition against Section 377 of the IPC was first raised by an NGO called NAS Foundation in 2001, which had approved the Delhi High Court in 2001. The Delhi High Court gave the judgment by decriminalizing the 377 in 2009, but the same was overturned by the Honourable Supreme Court, and the Honourable Supreme Court restored the criminality of sexual relationship between same-sex adults in 2013. Then the Constitution Bench was formed of five judges led by Chief Justice of India Mr. Dipak Misra were unanimous in its decision to scrap the 150-year-old draconian provision of the IPC. Other judges that comprised the bench were Justice R.F. Nariman, Justice A.M. Khanwilkar, Justice D.Y. Chandrachud, and Justice Indu Malhotra. CGI Misra CGI Misra called Section 377 of IPC irrational, arbitrary, and incomprehensible, as it fetters to the right to equality of the LGBTQ community. What society what society think has no say on people's freedom. Justice Khanwilkar and Justice CGI Mishra opined that social morality cannot violate the rights of even one single individual. Justice Malhotra said that the society owes an apology to the LGBTQ community. They have been historically denied. They have been historically denied equal representation over the years. The judges also laid an emphasis on right to privacy, which was incorporated as a fundamental right under Article 21 of the Constitution of India in August 2017. The right to privacy the right to privacy as a part of right of life applies fully to LGBTQ community, remarked former Justice CGI Deepak Misra. He further added that the state has absolutely no business to get into controlling the private lives of LGBT community or be it any other system. At last, I would like to conclude that the I would like to conclude by saying that the five-judge bench upheld the constitutional morality and principle of and completely decided the matter on the question of law, which was not based on referendum. The Apex Court held that the firm stance that no community, be it however small to the majority, could be deprived of sexual right or sexual orientation. Thank you so much.